going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Sunday night. Hope you guys are all well. Hope you guys had a great weekend. I've got some court. I've got actually the first case I have is on the thumbnail, and it's an interesting case. It's actually a really sad case too. So I've covered this guy multiple times. Unfortunately, most of the clips I have are from before I was demonetized, which I had to remove all those videos from YouTube. And I need to go back and check my download folder to see if I kept this guy's exam. So his name's Isiah Williams. I might still have his exam. I need to go back and double check. But I'm going to run through the basic of the details of this case with you real quick, just so everyone's up to speed before we get to this court hearing. Now, first off, his trial, they schedule his trial for this. I think this is the final pre-trial conference. But so this guy is being charged with the unaliving of his daughter. And his daughter hasn't been seen for about 40 years. That's how long this case has been going on. Now, the details of this case, from what I remember, are he took the daughter from the mom, again, about 40 years ago. You know, in today's standards, it might be kidnapping because I don't know how the parenting worked. I don't know how any of that worked back then. But so he took the daughter, kind of was, running around with her. He stopped by a couple of his relatives' house. So some people saw her, still alive. And then all of a sudden they started seeing him without her. And the mom was still trying to get her back this entire time. And his story is somebody kidnapped her randomly in a park. And that's why nobody has seen her since. That's his story. And he never called the police. He never did anything. And it's taken this long just to get him indicted, put in jail. He may have even been in jail on something else. I'm not exactly sure. But that's kind of the background of this story. And he is finally going to court for this. Now, they haven't found her body. So this is a murder trial without a body, which is already extremely difficult to do. But again, Google the name if you want the facts. I'm thinking about doing a really, an actual story on this guy and actually talking about the facts of this case. But I'm waiting till after the trial. So, there's an ending to this case at least. So let me know if you want to hear that or if you just want me to keep covering just normal court content. But that is something that I've been wanting to do. So anyways, now that I've spent 3.5 minutes talking about this case, let's go. Before I hit that play button, you know what to do. Hit the like, subscribe, do your jump kick backflips. Let's go.
Versus Isiah Williams, 24265 FC.
Good afternoon, Your Honor. Danielle Russo-Bennett on behalf of the people.
Good afternoon, Your Honor. Alex Peterson on behalf of the people.
Good afternoon, Your Honor. Good afternoon, Your Honor. Marcia Cracher on behalf of Mr. Williams. Mr. Williams, can you let us know if you can hear us?
Yes.
Okay. Today's the date and time set for a final pretrial and also a motion hearing. I believe the defense motion for requesting dismissal for a due process violation. So I've had a chance to review the motion and the response. I'm happy to hear from either counsel or any counsel on this, and otherwise we'll proceed with that. And then I should let the record reflect, we did have a status conference at 1:15 to discuss the logistics of the trial and timing of it and jury selection. And so I think we're basically final pre-tried. But go ahead, Ms. Cracher, do you have anything to say about the motion?
I do, Your Honor. Briefly, I know the court has reviewed the material that I submitted. Your Honor, this case.
This is Judge Colin. He's out of Michigan. He's around the same area as Judge Simpson. Whenever Judge Simpson has to send somebody to, is it circuit court? I think it is, for certain sentencing and, to push, higher up cases down the line. He sends them to either Judge Slay or Judge Conlon. So this is Judge Conlon.
The circumstances arose in July of 1982. The initial officer in charge, Detective Canada, is no longer alive. He's deceased. Unfortunately, also is Detective Seaford and Detective Caldwell. During the preliminary examination, who I presume is going to be the officer in charge at trial, did not pick up this case until 2011. He had no ability to reach out to Detective Canada or his predecessors because they were either unavailable or deceased. Moreover, what is bothering is that at preliminary exam on page 36, starting at line 23, Detective Iverson testified that, yes, Detective William Canada in 83 through 87 was the OIC. Then there was Detective Seaford and then Detective Caldwell. And then
No, it just started. I spent about 3 to 4 minutes talking about who this guy was and how interesting this case is. But I just started playing the video.
languished going to page 37, line 1, open cases for several years before I received it in 2001. There seems to have been a great gap in the investigative efforts of Ann Arbor Police, which I believe is a due process violation. My client does not have access to full reports because they were archived, and moreover, due to the case languishing in the AAPD, leads in that were not followed up on. As I laid out, hundreds of leads have come in during the time frame of this case. We are now unable to pursue those leads relative to potential sightings of Alyssa because the information is stale. And I offered to produce the Detective Iverson sheet to the court if they wanted to see it, but I was concerned that there was a protective order and I didn't want to violate the protective order. Further, there was what I think really shows a prejudicial effect to the defendant is that one of the witnesses testified not only a preliminary exam, but moreover.
Hey, thank you so much, Philip. Thank you so much for becoming a member. I'm guessing that you've been a gifted member before, so that's why it says new member. But I appreciate it. Thank you so much, bud. So I can't really say welcome to the family, but because you've already been here. So, but members only tomorrow. That's a good thing. And Paul, I don't want to go through it again because it took me a long time to spit it out. If you want to rewind back to my intro, I explained it there. Yeah, I don't want to spend another because it took me about 3 minutes to spit it out.
Over to Detective Canada about a Adrian connection, which I outlined in prejudicial circumstance number 1. We've attempted to follow up that lead. It's alleged that the defendant stated to Miss Reese, Miss Williams at the time, that the baby was with some friends in Adrian. We cannot track that down. The pastor of the church is deceased. The secretary of the church is deceased. We have no way of tracking that down. And I think that may possibly be a valid lead to the defense that he's prejudiced in following up because those particular witnesses are deceased. What I find overarching that is most bothersome is Detective Iverson took the case over in 2011 and continued to work the case till approximately 2021. There is no new information, no new evidence that was put forth by Detective Iverson or uncovered Detective Iverson. Therefore, the people, the government of the United States, government of the state of Michigan, had the ability to prosecute this case approximately in 2000, and they didn't. Now they bring this case in 2022, I believe, and we cannot accurately and zealously defend this case because the defendant's due process rights have been violated because he cannot appropriately research witnesses or do anything necessary to put up a defense. Like I said, there has been no new evidence that has been unturned since this case actually began in 87, Your Honor. And so I would ask the court to dismiss this case for that reason. Thank you.
All right, real quick on that. So I think it was a week, maybe 2 weeks prior to this hearing. This is maybe 2 weeks old at this point. So maybe a month ago, she stood before the court and tried to withdraw. So the reason why I started covering Isiah Williams isn't because of the details of this case. I had no idea about the case, which generally I don't. I cover court clips that I think is interesting. I know nothing about the case itself, but he was acting a fool. He's, fired multiple attorneys. Multiple attorneys have withdrawn, and Kreitzer tried to withdraw, and the judge said no. There's been way too many withdrawals. This case is 40 years old. You cannot withdraw. I'm not letting you. And she was very disappointed in that. And then she just turns up, and actually fights pretty well for a dismissal. It's not going to work, but good for her for at least trying. She not passionate about what she just said at all, but she tried.
All right. I'm just deferring to you, Ms. Bennett, but either counsel can respond if you need to. I've had a chance to review your response, so whatever you need to add.
Yes, I will just be very brief with this, Your Honor, because I know that you have gone over both of these.
How nice to hear from you. Go ahead.
Yes, hi. So I guess with respect to the first argument that this was just languishing in Ann Arbor Police Department and that there were reports that I guess may have been missing or that there were partial reports. All the police reports have been turned over to the defense. They have the same police reports that we do. And I did address this in the response about the potential lead with a reverend in Adrian, and it was based off of a statement from, I believe, that Elizabeth Reese. However, if the defendant had given this child away, he would be the one that would help his own defense and to help find and locate.
All right, I can't let this go. Lexa, I've said many times before, and I didn't want to say this on a live, but I will. She reminds me of Professor Flitwick, if Professor Flitwick was a lawyer and a female. Yeah, let that sink in. For you that know, yeah. Also, thank you, Kayla. I don't want to forget your milestone super chat. Thank you so much, Kayla. I appreciate it. And thank you for being a member for 2 months. That's awesome. I appreciate it.
This couple, if he in fact did such. And I guess finally also, the defendant was interviewed in 2021. So there was follow-up after, 2011, contrary to what the defense is saying. And it is also up to the prosecutors, when to bring a case. It's up to the prosecutorial discretion. And furthermore, this started out as a missing child case. This wasn't always going to be considered a homicide. And part of the case is the time that has been spent between Lisa going missing and the charges being brought forth. And so for that reason, we'd ask you to deny the motion.
Okay.
If I may respond briefly, Your Honor.
Ms. Kreitzer, it better be brief
It
because
is.
I've read everything that you filed and I just listened to everything that you filed come out of your mouth again. So what's new? Go ahead.
In response, it's not the defendant's responsibility to produce evidence. It's the prosecution's responsibility. And so whether he was interviewed in 2021 or not, it's up to the prosecution.
Yeah, that's why I said if Professor Flitwick was an attorney and a female. So yeah, the charms professor in Harry Potter is most definitely a male.
And as far as a missing persons case goes, well, the child allegedly went missing in 82. Detective Canada took over the case in 2021. I don't believe it was still a missing person case at that point. Therefore, I don't think that the prosecution has offered enough to show that the defendant was not prejudiced and his due process rights were not violated.
Okay. All right, to determine whether a delay in arrest amounts to a due process violation requiring dismissal, a two-part balancing test should be applied pursuant to People v. Bizarre on 114 Mishap 784 from 1982. First, the defendant must show some prejudice, and then the people must show that the reason for the delay is sufficient to justify whatever prejudice resulted. After review of the brief submitted, the defendant hasn't shown any actual prejudice has resulted, and the people appear to be more at a disadvantage because of the delay in prosecution. This court agrees with the prosecutor's analysis here. There's been no prejudice shown to defendant. If any side has been disadvantaged, it's the prosecutor. The investigation has been ongoing since 1982. Several witnesses for the prosecution have died. This impacts their case in chief, not the defendant's ability to meaningfully defend against this charge. There's no tactical advantage to the people, and they have a mighty case to present. A circumstantial homicide with no body. The motion is denied, and I'm going to request that we have an order entered by the end of the day. So, Ms. Kracher, if you can submit that order, we'll sign
Yes.
it and we'll be ready to go to trial. Okay?
Yes, Your Honor. Thank you.
Thank you.
Judge, there was two additional things that during our pretrial conference, you had asked me to make sure I put on the record.
Yes.
There
go
was
ahead.
one,
Oh,
I
right.
would, sorry, go ahead, Judge.
No, go ahead. I remember now. It's all coming back to me.
Okay, there is one, but I am going to ask for two witnesses to be permitted to testify via Zoom. One is Nicole Holmes from the National Center for Missing and Exploited Children. She's Alyssa's case manager in the long-term missing unit. She is going to just have she's not a material witness, I wouldn't say. She's going to offer basic testimony about the organization and work done to locate Alyssa.
Yeah, this happened back in 80. Well, I think 82 or 87. They keep saying 87, but when I was looking up the details before the stream, they were saying 82. Yeah, there was a lot less, ability to, how do I say this? Technology wasn't there. So now if something happened to, a child, it would be a lot easier to track and to find. So yeah, it wouldn't go on for 40 years, but yeah, it is very difficult. And that's what I said at the beginning. The prosecution is going to have a very difficult time with this case. Now, we can all think that he's guilty of sin. During the exam in Judge Simpson's court, in my eyes, he was. But, it's not a jury. That's just an exam. But, yeah, they still have to prove it. And without a body, it's very difficult.
Because she's out of state, it would be a tremendous inconvenience and I think a waste of the court's time to bring her in, fly her in, get her a hotel room when her testimony would be very, very brief. So I would ask for her to be allowed to testify. Additionally, Kimberly Bush is one of Isiah Williams's children. Her testimony was relatively brief at the preliminary exam. She is out of state in a work trip that week. And so me bringing her in person would likely mean Friday of that week, if not into the week of the 20th, where we have an overflow week for us if we're not able to get it done that week. I think that wastes the court's time. If I can get to her testimony Monday or Tuesday via Zoom, then I'm not wasting the court's time calling witnesses out of order, delaying the trial. And so I would ask that both of these witnesses be allowed to testify via Zoom. I understand Ms. Kracher has not had any meaningful.
Yeah, I don't think he has been. I don't think he's been locked up since the 80s. If I remember right, his exam was in front of Judge Simpson about 6 months ago. So I know that because I covered it. And that's when I learned who this guy was. But I don't think he's been in jail that long. I don't think it's been this long just to wait for an indictment on a charge. I think he's been out and they finally just decided to charge him. But I do think that he was in jail for something else. I think they finally caught him with something else, and I think that's what happened. So he hasn't been in jail for 40 years on this.
Conversations with her client, but I'm asking this to be permitted by the court.
All right, Ms. Kracher, what are your thoughts?
I would object to anyone testifying in this case via Zoom. This is a circumstantial case. Therefore, I think the jury needs to be able to judge witnesses' credibility, and that goes to witnesses' nonverbal communications, witnesses, how they appear in person, not via Zoom. That's why we don't do trials much anymore via Zoom, is because of that reason. And I think that allowing these witnesses to testify via Zoom would diminish the jury's ability to judge credibility and also would be prejudicial to my client. Thank you.
So the people have requested that 2 witnesses appear via Zoom. And so the first one appears to be, I'm not summarizing that she is a record keeper, but that she is going to testify not to personal knowledge of the case, but more of the handling by an agency of a part of the investigation of the case. So that's easy to me. So I'm gonna overrule the objection, I guess, or grant the request for the first witness to appear via Zoom. The second witness is more of a fact witness in terms of the actual events of the case, but because of a work situation is going to be out of town. I guess what I would say is that for purposes of this trial's efficiency, I'm going to go ahead and grant that request too and overrule the objection. I suppose, Ms. Kracher, if it really is that testimony is significant and you assess that that testimony is incredibly impactful, then I would allow a motion in limine, I guess, to follow up with some more in-person testimony. I'm not saying that's a given, and I'm not saying that's the right answer, but let's see what happens. I mean, you've been in the courtroom, the TV is larger than a person. So the idea of the jury not being able to see the testifying witness is a bit of a mischaracterization. I'm not saying you're doing that, but you've seen the giant TV. So believe me, you are larger than life today on that TV, and that witness will be as well. So if there is something that the witness does yield that somehow would require in-person testimony for for Mr. Williams' right to confront any witnesses, I'm willing to hear that motion on that day, but let's go ahead and plan on it being by Zoom, and we'll see if it's significant or not significant, and thus not going to delay the case. Okay?
Thank you, Judge.
All right. So
Your
if I could have those orders by close of business today. Thank you.
Judge, I just want for the record.
I don't know. I don't think so. I don't know about the beard and the mustache, but the reason he caught my eye is because he kept firing attorneys and he was kind of soft sit-ish. He's about to talk here shortly. So you'll see why he caught my eye and why I started covering him. But I don't remember the beard and mustache, but he likes to talk a lot.
Mr. Williams is unmuting himself and attempting to speak. I just want the court to be aware.
Oh, I did not see that. Mr. Williams, you are actually still, there you go.
Your Honor,
Yep.
as it plays the court, I'd like to speak.
Briefly, sure. Yes.
Yes, Your Honor, I at the time of being dismissed as my own counsel, and you had stated something to the fact that the one who was at that time was supposed to take and be a co-counsel, or that was Mr. Attorney, I believe it's Fister, Feastr, and that did not carry through. The next thing I heard was the present attorney who's now there, I believe Marshall, last name Kraycir, presenting as the counsel for the defendant. And I have a question with that, and the court appointing her as counsel on my behalf. I have brought to her attention the name of each of my witnesses that I need for trial, as well as documents of other court records that states involvement of me as a person and events carried out by me as a person that's totally not of my knowledge. I'm a TBI, traumatic brain injury, and bipolar defendant. I was discovered by doctors and claimed that I was dead brain, being a dead brain individual from poisons in 1990.
Jail nails are a thing. They are. You keep one nail long so you can cut things a little easier. That's a thing. Don't ask me how I know that, but yeah, that's a thing. That looks a little ridiculous though. No one needs it that long. Hopefully that's a Band-Aid or something.
5. my knowledge of anything begins in 1995 to the present. So I brought this to the attention of her and made it plain that I had witnesses that I need to have brought to court to be able to cross-examine them in hopes of bringing some of these alleged incidents of my steps to my attention, as well hopefully to my memory. And also of court transcripts that claimed that I had been before the court and certain things was made in the court that I have no memory or knowledge of. These things that I feel is pertinent for me to be given the rights under the law. I'm not even allowed even to be in the courtroom to actually take and even be when a eyewitness who was Detective Iverson in this case, and his testimony, I wasn't even allowed in the courtroom. And I don't understand that. And the law makes it plain that I am supposed to be in the courtroom to face my accuser.
Right. You do have that right, sir. So let me reflect a little bit of what you just said, though. So you have some concerns that there was a prior relationship with an attorney, and then you represented yourself, and I appointed a standby attorney, and that didn't work out. And so then I appointed Ms. Kracher. So you have had a number of attorneys. That is true. I believe you've had 3 or 4, and you've attempted to work with them, and some things have broken down. And so we're here today with Ms. Kracher representing you, and she is doing her level best to protect your rights, and she's filed motion after motion. She's filed request after request, and so we've kind of dealt with all of that. We're now coming up to the trial. So the way the state of the law is right now is that anybody who's in the Washtenaw County Jail for a motion or a pretrial or a final pretrial, they appear via Zoom so they can be present in that way. And you're correct. At your trial, you have the right to be in the courtroom. But I understand from prior activity or prior review that at the preliminary examination, there was some outburst or there was some behavior that caused you to be removed from the courtroom. We're not going to start that way, Mr. Williams.
See that right there? I knew there was a reason why I started watching him. He's a talker, and during the exam, I remember something wild happened. And all right, I'm glad Judge Colin just said it. Also, whoever said they had, it was Peb. Peb, I hope you feel better soon, man. And I'm glad the fun court clips got you through the weekend. So, but get better soon. Drink a lot of water. Get your electrolytes. I wanted to say one more thing before I played. Don't remember what it was. Oh yeah, no, yeah. Ever since I said the jail nails thing, I was looking like, oh no, all of his nails are long. That's not okay. And I've been looking at mine. I was like, I could definitely clip mine. All right, that was it. All right, let's go.
We're going to start with you being here. You're going to be dressed in street clothes, and as long as you behave yourself, and that's not a subjective matter, that's really for the jury's purposes. If you behave yourself, you'll be sitting in court confronting your witnesses at every turn, and Ms. Kracher will be questioning them. You'll be talking to her. You'll be suggesting questions. So there will be a whole process that we go through. But what we can't have happen is what happened at the preliminary examination, where your behavior was such that you had to be removed from the courtroom. If that happens, we will accommodate a video feed so that you can see what's going on, but you won't be in the courtroom to confront your witnesses. So I'm absolutely open to that happening, but we can't risk a mistrial and your behavior toward the jury without, curative jury instructions to allow that to happen. So in other words, if you're good, I'm good, the jury's good, we're going to have this trial. But if any one of us is misbehaving, you, me, or the jury, I have to do something about that. And so I have to run the trial. So that's my job, and I'm going to do it. But otherwise, I'll see you then in about a week or so, and we will start our jury selection. So I'll look forward to meeting you in person that day.
Your Honor, my question to the court is that she has denied my witness subpoena. And I'm asking,
I don't know who she is. Your lawyer has filed a bunch of motions, so I don't know who she is, but we're going ahead with the trial based on the witness list
You're saying,
submitted.
Your Honor, that I'm denied that I have my rights to have my witnesses at my trial?
Your lawyer is handling your witness list, and she has
No,
submitted
she
it.
had denied
And we
it.
are
Is it tomorrow already? It's this month. I don't know if it's tomorrow. Did they say in this video yet? I don't know. Also, no, I don't know if he had a paper bag with him or not. I don't remember that. Probably. He's been wild trying to defend himself and saying some outlandish things. So I would believe it if he just said he did have a paper bag with him.
ready to go. But I would suggest, Mr. Williams, that if you need to communicate with your lawyer, arrange for her to come out and talk to you, and she'll do that. Okay?
Your Honor, so the record is clear. I attempted to see him on April 10th, and he refused. I attempted to see him today, and he refused. Mr. Williams, I'm more than willing to sit down and talk to you about your witness list, and we can carve out a witness list that will work.
Okay. So when do you want her to come out there, Mr. Williams? When are you going to see her?
What I would like is for my witnesses, as I request, to be brought where they can be able to testify in court on my behalf. The witnesses that I have provided, that they be subpoenaed, you understand, within a time limit, you understand, for adequate, you understand, registering for the trial. That's all I'm
I know,
asking.
but the
because
difficulty
because
is
my
that if your
constitutional
lawyer comes
right
to see
have
you
my-
last week and this
And
week
he
and you
said,
don't see
"No,
her,
I'm not gonna
that
do that."
impedes the process. So I don't know what else to tell you, sir. But if
Well,
you
I
want
tell
to
you
make an
what,
arrangement
then,
to see Ms.
if you want
Kracher,
to give
I
me
would
my
suggest
rights,
you do
then
it right away.
Thank you.
All
I
right, that
appreciate it
concludes the
then.
hearing,
Thank
sir.
you.
Thank you very
You have a
much.
blessed
See you in a
day.
week.
Peace of God be with you and the family.
Okay,
Thank you, Your
next
Honor.
case.
Thank you, Judge. Have a
Thank
good
you.
day.
Yep.
Number 17, people.
Alexa, he had Feaster representing him at first, and Feaster either withdrew or the guy fired him. I don't remember which one. But yeah, she's like his third or fourth attorney, and she even tried to withdraw about a month ago, and they told her no. All right, what do we got? Grizzly Fart, thank you so much. Remember for 2 months, that's awesome. I appreciate it, Grizzly Old Fart. Thank you. All right, what? Isiah Williams, right? Yeah, same case. That's it. Starts Monday. I'm sure I heard jury selection starts Monday. Yeah. Okay, so that would be tomorrow. So Colin's probably not going to be on all week because I don't think they're going to make that public. And I know there's something going on where Judge Colin said that they only get like a week for this trial because he has something going on next week. If this is this Monday that they're talking about, and Judge Colin said, like, we're going to get through this trial if we have to stay till 10 o'clock at night, every night this week, but we can't let it go on because they tried to push it out for like 2 more weeks because I think Judge Colin has something next week where he's not going to be in court. So, yeah. So if that's this week, if it starts this week, then yeah, maybe another reason to go to Detroit this week. All right, next one. I wasn't just going to play that. That's a sad case. I think this is Judge Simpson. All right, Judge Simpson.
And Matthew Mansour, the public defender, with and on behalf of Mr. Radke, who appears on my right. James, can you state your name for the record, please?
James Radke. Thank you, sir. What are we doing?
Your Honor, I was just going to ask for a short adjournment here.
Yeah, that's Judge Conlon. Judge Conlon generally has a docket on YouTube once or twice a week. I will look to see if potentially the jury trial is on YouTube, but most likely it won't be. But that's such a huge case. I feel like there's going to be media covering it. So maybe, we'll get some information from the local news, but I'll check it out. It's definitely a case I'm interested in. So I'll do my best to see what I can find for everybody.
I'm going to look into see if we can get him. Sorry, I don't know why I always say here.
I don't either. I don't know. Because I guess you asked for adjournments there too.
Yeah.
All right.
Yeah, I need to request an adjournment just to see if I can get him into
May 16th, 2024 without objection.
May the people who are on?
You may.
Thank you. Your Honor, at the time the defendant was arraigned, he requested a $50,000 charity bond, and that was raised.
And as I always say, when the prosecution brings up bond, it's not going to go well. We generally get a Mr. Allen.
The defendant $50,000 charity bond was 10%. I think that I'm asking the court to review that for an abuse of discretion. This is the defendant's 11th or 12th OWI. That we can see. His priors are from 2020, 2018. There were 2 in 2012, 2005, 1995, 1993, 1992, 1989, 1988, and 1986. And specifically, he got for OWI.
What year?
2022. The concern for people is for the public.
All right, I don't know what Judge Simpson's court did with the prosecution and their audio, but it was bad all of last week. So I apologize for that. It's not on me, but we hear a lot of paper shuffling, which is kind of annoying. But if you didn't hear, this is his 12th or 13th OWI. That's what they started this argument with. So just so everyone's on the same page, 12th or 13th. Once you get that high, you don't really remember. Even when you're reading charges, like I don't know, it was in between. It was double digits. That's all I know.
Master plays on the scrum cutter and there's been no indications that he's violated. That was right. This morning, but this pervasive and ongoing history of OWI is of extreme concern to the people, the safety of the public.
Your response?
Oh, Your Honor, Mr. Red.
Oh, Donald, whenever there's one of the male-friendly attorneys, even if it's a boring clip, I will put them on too. I make sure the split is equal. This one isn't a Mr. Allen clip. This is what is wrong with this guy clip. That's what this is. But yeah, we do get a Mr. Allen here.
He is a Navy veteran, disabled veteran from 1982 to 1985 with an honorable discharge. He's Michigan born and raised. He resides in Wayne. He regularly attends AA meetings. Last time he attended an AA meeting was yesterday, and he attended 2 of them. He also let me know that he voluntarily has looked into checking into an inpatient treatment program in Detroit. I believe it's called Life Challenge Inpatient Treatment Program. It is Christian based, and he let me know
How
that.
come he isn't in an inpatient treatment program now?
Well, Your Honor, he has been going to AA meetings, and it's an up and down battle with Mr. Radke. And
I understand that, but I also understand that he served prison time for drunk driving. Was released in 2022. And by 2024, I'm back here again with this. Right?
yeah, that's correct, Your Honor.
What was the alleged BAC in this matter?
Yeah, that's a really good question. We're still awaiting the blood results. This was a single vehicle crash that occurred. The defendant.
There was an accident?
Yeah, he crashed, a single vehicle crash. And the
Mr. Allen.
All field sobriety tests, all.
There we get it. Man, words. There we go. Mr. Allen. He said it so quickly during the Miss Londy's I don't want to call it a speech. Can't think of the right word right now. Again, words are hard. But I paused it to say thank you to Kathy. Kathy, thank you so much for the 5 gifted memberships. You are awesome. I appreciate it. Members Monday is tomorrow night. I've got a good one for. I might actually wait to do this for Tuesday night. I don't know, but I've been working on a story of a judge. Her name is Tracy Hunter out of Cincinnati. If Peeps is still here, she knows who this is. But I've been, actually editing a long form kind of, not really a documentary, but more of a actual story. Kind of what I was saying about Isiah Williams. If you want me to do something along that style with Isiah Williams, I will. But this case is interesting. She was a judge, and she got kicked off the bench and put in jail for 6 months. And so I've been working on a story. I might do that Tuesday night instead of tomorrow night. I don't know. Maybe I'll show you guys the rough draft tomorrow. That actually sounds like a good idea. Okay, let's keep going.
PBTs and the blood, as the blood draw as well, and we get a warrant. So we're still waiting on that, but we did charge the case given the history. And I will let the court know too that at the time that the defendant was booked into the Washtenaw County Jail while awaiting.
Yeah, Peeps, she's out. She's been out for a little bit. So she got a 6-month sentence, and she tried to appeal. She fought it for so long. She fought it for like 4 or 5 years. It might have even been 6 years. She was fighting the 6-month sentence, and they finally said enough is enough, and she served her 6 months. Now she's still trying to get the whole thing thrown out, and she's still trying to come back as a lawyer. So she was just in the news a month or two. Let's see, it's May. I feel like I saw her name pop up 2 or 3 months ago. But yeah, it's still very relative.
Medical examination. He did submit to a PBT at the jail, which was a 0.147
That was at the time, 147 at the time of booking.
at booking. That's right, Your Honor. But of course, the court knows we won't be able to use that number for our case, but that was the PBT at the time of booking.
Anything else, counsel?
Your Honor, Mr. Radke was arraigned in front of the Honorable Magistrate Fink. I believe she appropriately set the bond here at $50,000, 10%, with a scram tether with a no drinking, no driving standard bond conditions. Yes, there was an accident. Nobody was physically injured. He has been on scram.
We had a blessing.
He had a blessing, but from what the alleged report says, nobody was injured. He checked in today early at Community Corrections. His agent is Mr. Levitt. They downloaded they gave him a main base device for his home so he can continually test at home. He has had no issues since he's been arraigned. He is compliant with all of the bond conditions here. And he's
Counsel,
here.
you say that to me, but we're a week out from arraignment. It's a week.
I know, Your Honor, but I'm just trying to.
No, go ahead. You make your argument.
Yeah, I'm just trying to let the court know that, Magistrate Fink heard both arguments. I believe she set the bond at an appropriate bond. If Mr. Radke would have known that the bond was.
We don't know if he was driving legally or not. I'm going to be willing with that many DUIs that he doesn't have a license, or maybe he's allowed to drive to and from work. I don't know, but I would say that he probably doesn't have one. And another reason why I think Miss Londy said 12 or 13 is what happens a lot of times when you start getting these really high number of DUIs, they'll charge them as like a third. So it might be your fourth or fifth DUI, and they'll charge them as a third. So it makes keeping the numbers straight a little bit more difficult. But also, when they're in double digits, why are you out? How many times? Okay, I'm gonna get off my soapbox. Let's go.
Would be raised. He would have never posted a $5,000 bond that he had to use on his credit card. His son, he had to call his son here. His son is in the courtroom now, trying to take care of these matters. I'm just asking this court if it would have any leniency for Mr. Radke to allow him to continue to do what he's been doing and get these matters taken care of here. For you, regardless.
Now, after all of that, Judge Simpson still wants to help this man. He still tries. He doesn't let him out. He's going to jail. So, spoiler alert, Mr. Allen was not a front. He goes to jail. But he cares. He tries to help him. God forbid he come back in front of Judge Simpson, though.
I believe that given the defendant's record in this matter, given the fact that we don't have the test back, but he was almost a 0.15 at the time that he was booked in, that further that there.
Yeah, he paid $5,000. He paid it out of his own pocket. So he paid the $5,000, which he was given a 10% of the $50,000. That's the problem, is he paid that bond. He's out. And the prosecution brought it back up, and the judge is like, listen, like, you're lucky to be out. You had a week of borrowed time. I don't know why Judge Fink, gave you a bond that you could make. So I think that was going through his head. But yeah, but listen to what Judge Simpson says. I'm going to let this clip play out.
There is an accident that has occurred. Also, given the defendant's record that he had just come off parole, basically in 2022, we're back in 2024. He's done this again. This is not by any stretch of the imagination necessarily an attempt to punish the defendant, but I believe that the defendant he may be trying his best to do what he's doing, but what he's doing right now gives the court serious concerns or pause. I don't believe that the magistrate in setting the bond, I think that there has been an abuse of discretion. I'm going to set the defendant's bond in the amount of $50,000 cash or surety bond, no 10%. I will, however, do this. Make a decision. You said that the money was paid on a credit card. I don't have a problem refunding the bond that he's paid if he needs those funds to pay for inpatient treatment. So he can be released to inpatient treatment. I'm phrasing it that I'll consider release to inpatient treatment. I'm not saying on a PR at this point, but if he needs those funds and you let us know that he needs those funds to get himself into inpatient treatment, I'm not going to have a problem with that. I want him to have help. I want him to not deal with I want him to be able to deal with the demons that face him. And I don't want him here on an OWI causing death. And I think that I need to protect the community, and that's how I'm going to do it.
Okay, Your Honor. Can I ask to approach, please?
You may.
Thank you.
All right, record should reflect that we had a bench conference just in terms of the details. And again, so that I'm very clear on the record, I don't have a problem refunding what's been paid, provided that goes to inpatient treatment.
Okay.
All right. And so I just need you to arrange that, get with the prosecutor. You guys give me an order and I'll sign off on it. Make sure if there's a cost to the inpatient treatment and you want the bond returned for the payment of that, make sure that portion is contained within the order.
Yes, Your Honor.
All right.
Thank you.
Thank you. Defendant is remanded. There is only one, I think, that one.
All right. This next one gotta shift a little bit. First case was sad. That one was kind of frustrating, also sad. This next one, a little frustrating, but at least we get a little drama in court. This KCC did play this last week. She had her follow-up yesterday, and I was waiting to play this case until the follow-up that was not yesterday. That was supposed to be on Friday. They didn't air it. It wasn't on YouTube. So I didn't get to see the follow-up, but I was waiting because I wanted to see it. So just so you know, I tried. I waited for the follow-up. It's not there. I don't know how this concluded, but here's a quick 6-minute, how dumb can you be type clip.
Frederick Kruger, 24-207-624 PP. This is the petitioner's motion to terminate a personal protection order. Plaintiff is present in the courtroom. She is in pro se. The defendant is in the courtroom in pro se. Will both parties please raise your right hand?
Thank you so much, Kara. I appreciate it. Thank you so much that's a very generous super chat. OHIO. I appreciate it. Yeah, thank you. Thank you. Very generous of you.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
They put your hands down. The court, back on January 22nd, 2024, had issued a personal protection order. The petitioner in this case, Ms. Blinkerman, had filed a petition with this court. On that date, the court, based upon the information contained within the file, as stated, authorized the petition. And the very first alleged incident that the court relied upon in issuing the personal protection order is as follows. The latest incident started in early to mid-December 2023 with mental and emotional abuse. December 25th was the final incident. Kent Kruger and I started arguing earlier that morning, which resulted in him, Kent, cutting my arm with a knife. which I received 5 stitches for later in the day. Later in the afternoon / evening of December 20th.
Is this audio kind of weird? Sometimes it's going through the mic and sometimes it's kind of being fed somewhere else. Is it just me? Are my headphones going out or can you guys hear that too?
25th, while his children were at home, Ken accused me of stealing baseball cards, got angry, hit me in the head with a metal box. Ken's daughter called the police and I was taken to the emergency room where I had been examined and received my stitches. There are other alleged incidents in this matter as well. Since the granting of the personal protection order, the petitioner has filed a motion to terminate the personal protection order, where on March 15, 2024, according to the document filed with the clerk of the court, I, Leslie Glinkerman, have good cause to terminate the PPO against Kruger. I lied about the abuse and made up the story of Kent cutting my arm.
Yes.
I did this so I would have a place to stay at the shelter. Ms. Glinkerman, do you have any comment regarding that?
I'm sorry that I lied and caused all this hassle of everything that's going on. It was a big mix-up about Christmas. It was a big mix-up about other stuff. I was mentally ill. He was also mentally ill, and I'm sorry.
Just a moment, Ms. Glinkerman. You had stated, you just stated a moment ago, alleged mental health issues, but you filed this on, the document that you filed with the court was dated January 1, but you filed it on January 16. Correct? According to the file.
January, yes.
Okay.
Yeah. She needs something. I mean, I don't know what the relationship between these, this is like the father of her children, I believe, or something along those lines. She said she wanted, I don't want to get into it. I don't, but yeah, the police, the court, so much time wasted. And that's why I wanted the follow up. They were 9 a.m. this past Friday was supposed to be her, contempt hearing, and it wasn't on YouTube. Still upset about it. You can probably tell because it's the second time I mentioned it in 3 minutes.
Because of where I was staying at.
So this is the problem with matters like this. In general, personal protection orders are extremely serious matters.
I can understand.
And your admission that you lied to the court, first, I'm going to terminate the personal protection order. That's number one. Number two, I'm holding you in contempt. As a result of that, at this time, I'm not going to make a determination regarding disposition because at this point, I'm going to assign an attorney to represent you. This is frankly criminal contempt. My understanding is, well, as a result of this, right, just a moment, please.
Yeah, I agree. I saw Jedi's message a minute ago. Yeah, I don't know Jedi. I don't know. Now I'm conflicted, but still, I'm gonna stay strong to what I think was going on. So yeah, I'm gonna stick there. Let's go.
You have an attorney representing you in another matter right now?
Yes,
What's that attorney's name?
Lockhart.
Mr. Lockhart? Okay. The court will appoint Andrew Lockhart to represent you. We will set this for a disposition hearing next Friday at 9 a.m.
Next Friday at 9.
Pardon me?
Next Friday at 9.
Next Friday at 9. Don't ever do this again.
Will not happen again.
I'll see you next Friday.
All right, like I said, that was a little quick one. What's up, Lori? Hope you're having a great evening. Yeah, she's in trouble. Yeah, again, I wish I had that follow-up. I waited to play that. I waited a week to play it. because I wanted to play them back to back and didn't happen. Okay. Do we have one or two more left? Let's see. Who's next? Who's next? Oh, all right. We have to do something a little bit more lighthearted, right? This isn't funny, but it's funny. Let's just say that. I feel like most of you are going to enjoy this. Some of you are going to be like, you know what, this is a weekend thing for me. All right, let's go.
Detroit versus Jaleisha Arnett Gatson, case number U67209-723. Appearance for the record, please.
Yes, sir.
Elwood S. Barrett Jr. on behalf of the defendant. State your full name, Ms. Gatson.
Jaleisha Gatson. Well, Jaleisha Arnetta Gatson.
All right, she wasn't scheduled to come in today. This is.
I think it's funny. I think it's funny. It's funny because the charge she has isn't serious, but the judge kind of makes fun. You'll see. You'll see. I don't want to give anything away.
This is
I wasn't, Your Honor. I had.
Hold on a second.
Oh, okay.
This is a case where she missed her trial date. Ms. Gatson, you missed the trial date, and the next time you do it, I'm going to put a money bond.
Yeah, Jedi, you put that in my head, and now I'm thinking the same thing because I couldn't tell if she was scared or ashamed. You know, it's just judging from the audio, it was really hard for me to see. Her body language could have kind of been both. I don't know, but you put it in my head now. Maybe that's why the hearing didn't happen yesterday. Or I keep saying yesterday, it's Sunday. Maybe that's why it didn't happen on Friday. She came forward and said, "This isn't what's going on. You know, I'm afraid." That could very well be.
On you, so if you get picked up, then you're gonna have to pay some money next time.
There's an issue there. The court dates are being sent to my mother's house in Ohio, and I live in Michigan in Dearborn Heights. So I'm not receiving the notices because they're not being sent to me directly. So if I could
Did you hear that, Kara? OH. Hopefully Kara's still here. Let me get it. Let me get the rest of it, Kara.
update my address.
I will allow you to update your address, but you were here in person and you got that court date, and you neglected to write the date down, obviously, and relied on the mail to.
No, sir. On the record, if you would look back, you said that you would send me a notice because it says I'll set it for trial, and it was one day in March, and I was supposed to receive that notice in the mail. I did not neglect it.
I didn't give you the date.
No, sir.
I don't.
It's got to be on the record.
No,
I don't lie, sir. I promise.
I just don't believe it, but we're not gonna go there. What's your updated address?
4908 Polk Street.
490 what?
8 Polk.
And what's this, Detroit?
Dearborn Heights, 48125.
48125. Enter not guilty plea, $0 bond. I'll recall the warrants now. I'm giving it to you now. July the 11th, 2024 at 9 a.m.
Is there any date sooner than that? That's actually my son's birthday, and we're planning to go to Myrtle Beach.
No, it's no date sooner than that.
Will I be able to log in from South Carolina?
You will. Well, I have to give you permission to go to South Carolina first.
Okay, are you able to do that?
Yes.
Thank you.
All right, 7/11/2024 at 9 a.m. We can give her a date past that if you want something further out in the future.
Sir, is there any way, I don't want to go to trial on this matter. Is there any way that we could resolve this today?
Plead guilty, and $240 fine. I'll dismiss upon payment.
Yes, sir.
Speak to Ms. Bradfield and Mr. Barry in a breakout room.
Okay, is there any way that I could get a lesser penalty so that if it comes up, you know, in the future, it's not like I'm just exposing myself in public or urinating in
It's gonna be
public?
on the record that you exposed yourself in public. You wanted to take the deal, that's the deal. It'll be dismissed. But the record will, you know, we have to take an accurate record that you actually did what they say you did, all right? So
Okay,
speak to
but
Mr.
then, but you said it will still show as dismissed?
It will show as dismissed. Speak to Mr., if you pay the fine, it will. Speak to
Yes,
Mr.
sir.
Berry. He'll explain things to you.
Okay, I appreciate it. Thank you so much.
All right.
All right. I know I didn't edit this out. I was waiting when he said talk to your attorney in a breakout. I'm like, no. I skipped right over this. So I think I fast forward
Now,
through this.
let's go back on the record with Mr. Glenn.
Yep. I fast forward through it.
You said something before you left. I'm not sure, I think you, let's go on, back on the record. Ms. Gatz.
Look at those fast forwarding skills. So good. So good.
Mr. Berry, I've given you an opportunity to speak with your client. What does your client want to do?
Yeah, I don't disagree with that. But asking multiple times is there was the person from Judge Washington's court a few weeks ago that kept saying, is there any way I can get no points for this ticket? And Judge kept saying, no, there's no way. But is there a way I can get no points for this? No, there's not. But is there a way I can, still pay the fine and get no? I think she asked 4 or 5 times. So that was a little excessive, but you are right. The answer is always no if you don't ask.
I'm sorry.
She would enter, she's prepared to enter a plea as charged, Your Honor.
All right, is that what you want to do, Ms. Gadsden?
Yes, sir.
Can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, sir.
Or you can put your hand down. You understand the maximum possible penalty for this offense is 90 days in jail and or $500 in fine?
Yes, sir.
You understand that you have an absolute right to a trial?
Yes, Your Honor.
Mr. Berry went over your other advice and rights in the breakout room, did he not?
Pardon me?
Mr. Berry went over your other advice or rights in the breakout room, did he not?
Yes, Your Honor.
You understood those rights?
Yes.
Do you have any questions about those rights?
No, sir.
You know, by taking this deal, you're gonna give those rights up?
Yes, Your Honor.
Has anybody offered you anything other than what's been stated in the record?
No, sir.
All right, I'm gonna have to go off the ROA, Mr. Berry, because I don't have a ticket in.
All right, Lori loves law. First off, I love the triple L. And all I keep thinking when I read your name is Bob blah blah, attorney at law. For those of you that know, you know, but Bob blah blah, attorney at law. Lori loves law. I don't know why, but they don't sound anything alike, but it's what it reminds me of. Okay, let's go.
In front of me, because Ms. Gadsden is a walk-in. Draw your attention back to July the 12th, 2023 at around 2:45 a.m. in the city of Detroit in the area of 401 Monroe Street. Did you have an occasion on that day to be in that area that date and time?
Yeah, I had met some friends at a place down there. I'm not even sure what the location was. It was on a rooftop. And I went down there with them.
All right, Miss Mason, what is the offer in this this urinating in public?
Urinating in public is delayed 3 months, Your Honor.
All right, so did you do that, ma'am?
What does the delay 3 months mean?
The delayed 3 months, I'm gonna better that, dismiss upon payment. But did you do what they said you did in here?
Your Honor, we were leaving a function. I've had, as I stated, a child. My bladder is very, very weak in any regard, in any situation. not just this one. In particular, I do have a copy of the ticket. The officer is stating that I told him that I urinated in public, which is why he administered the ticket and sent it to my mother's house.
Okay, so stop. So now what I'm hearing is you're not actually admitting to this. You're saying that what the officer said. So now, see, this is the problem of people coming in here wanting to get the stuff over with so quickly and not wanting to deal with it. But yet and still you're on the other end of that. You're worried about what the record is going to say. Now, are you going to admit to this, or is that going to be, or are you saying what the officer said?
No, I will.
Wait a minute. Do you need to go back in the breakout room and speak to Mr. Berry? It sounds like you do.
No, it doesn't, Your Honor. I just want to make sure that.
As a guy, yes, absolutely, I have. Absolutely. But it's a lot easier for us. Just saying. Not saying it makes it any more legal, but yeah.
We're clear that the when I discussed in the breakout room and what we stated before was that it was the 249.
Let me stop you. Mr. Berry, what is your client? Did you have a discussion with your client?
Absolutely,
okay. Did that discussion?
Did you hear the laugh? He's like, absolutely. He's like, we did talk about this. It was very difficult to talk about. She told me the whole bladder story too.
Did that discussion that you have, is your client prepared to give an accurate factual basis to the allegation?
She was. Your understanding? She certainly was when we left the breakout room, Your Honor.
You understand why the court is asking you this? Because of what she just told me, that the officer wrote on the ticket that she admitted to urinating in public.
The question put to her directly gives the answer directly. The need to explain the bladder situation and all of that is just something.
But I'm not talking about the bladder. When I asked her specifically, did she do this? She never admitted to doing this. She said that the officer wrote on the ticket that she admitted to doing it, almost as if the officer did not see her doing it, but she had that she wrote. Now, Ms. Gadsden, what is it? Do you want to have the officer come in and we set it for a trial date, or do you want to plead guilty and admit to urinating in public? What do you want to do?
All right, Your Honor, I want to plead guilty and admit to urinating in public.
Is that what you did at 401 Monroe Street? You urinated at 401 Monroe Street?
Yes, sir. In between my car door. Yes, sir.
It doesn't matter where it is. And you just said to the court, you know.
that does completely change the situation. You are absolutely right. And I don't know if you meant that to be funny, but I cracked up pretty hard. I was still laughing when I paused it. There's not that much time left of this. Let's see. Oh, there's less than 3 minutes left. So you know what time it is. I'm gonna let this rest of this clip play out. Thank you so much for joining me. Thank you all for the super chats. Oh, H. Thank you so much for the gifted memberships, the membership milestones. You guys are awesome. We'll be hanging out on Discord after this. Discord links in the description, but I'm sure one of my awesome mods will put it into the chat. Yeah, let's go hang out on Discord and discuss some things. All right, but I'm gonna let this play out. I will see you all tomorrow. Members only tomorrow night. Yeah. Have a great start to your week. Until next time. Bye.
That your bladder is not can't handle. It's a small bladder, and you said you just left the function. Wouldn't it stand to reason?
I know. I just said I was going to let it play through. I've been waiting for that, Jedi. ILL. I've been waiting for someone to say ILL. I really have. So I was born in Illinois. I grew up in Ohio. So I've been waiting for the ILO. All right, now I'm gonna let this play through. But thank you so much, Jedi, for bringing in the INI.
That, wouldn't you stand the reason that before you leave and you knowing that your bladder is not able to last long, wouldn't you stand the reason to go to the bathroom before you left?
Yes, but as I stated before, the location was at a rooftop and the event was ending. So there was obviously other people at that event that we were all being rushed out of that event at one time. So no, sir, it did not hit me at that moment prior to, oh, I should go to the bathroom right this moment. It hit me once once I got outside and that dusk wind hit my behind at 2 a.m. that I had to urinate. And I was like, oh my goodness, I don't want to urinate on myself or in my vehicle or anywhere else. So I was like, man, I'll just, go right here.
I don't know why I hit you there, and you already know that your bladder can't hold a lot. I don't know why you wouldn't think of that. That would be something that everywhere you go, you would, hey, let me go to the bathroom before I leave wherever I'm at, on any situation, especially after a night when you're drinking probably and 2:45 in the AM. But nevertheless, I'll find her guilty as charged. $240 fine. When can you pay it?
Can I have until August?
No.
Okay.
No.
When 30 days?
30 days. Come back May the 30th, 2024 at 8:30. At 8:25, if it's paid, we'll dismiss the case. If it's not, you need to let us know why, what's going on, all right?
So do I still need to appear if the charge is paid, if the fine is paid?
It's paid. If it's paid, we'll dismiss the case, but if you don't.
Yeah, no, I actually kind of agree. Because he could have answered that question she just asked. She asked it about 3 times before he finally says no. But he's like, do I have to appear if it's not paid? And, that's a yes or no question. And he was just on her for not answering yes or no questions. And he asked her yes, or she asked him a yes or no question. And he kind of avoided it. So yeah, no, that actually makes sense. I think he's just kind of frustrated with her attitude. All right, now I'm letting it play out. You guys all have a great night. I'll see you on Discord.
Don't want to see it through, then that's on you.
No, I'm asking, like, if I pay it before the 30th.
Yeah, if it's paid on here, I'll
show up to
dismiss
court
it.
on the 30th?
No, if you don't have to show up to court if it's paid.
Okay, thank
All
you.
right, have a good day. Best of luck to you.